Okay. You're not hearing anything? Am I on mute? Audio is fine here. Dina can hear me. Thanks, Dina. Audio is loud and clear, says David. Thanks, David, for letting me know. And I'm waiting for a couple more people here. Let's see. We've got some Q&A already going. Oh, apparently I have to unmute Aaron. That would help. I guess things change when, oh yeah, I can see right now. Did you get the, okay, cool. There we are.
So are we ready to begin?
I think so.
All right, great. Well, hi, everybody, and welcome. I'm Erin Daly. I'm the director of the Global Network for Human Rights and the Environment, which is a network of scholars, lawyers, activists, and others working at the intersection of human rights and environmental protection. If you're not familiar with us already, please do visit our website at GNHRE.org. And as Josh said, the video of this event will be posted there soon. GNHRE is launching a series of book events, and we're really delighted to welcome you to this inaugural program on a truly groundbreaking new book just published by one of the network's longest-serving core team members, Dr. Josh Gellers. Josh is an associate professor in the Department of Political Science and Public Administration at the University of North Florida and a research fellow of the Earth System Governance Project. I first got to know Josh when he served as a visiting scholar in residence in global environmental constitutionalism at Widener University Delaware Law School in 2015. He has also served as a U.S. Fulbright Scholar to Sri Lanka in 2017. At UNF, Josh has received the 2016-17 Outstanding Undergraduate Teaching Award and the 2018-19 Outstanding International Leadership Award. Earlier this year, he was named the Green Teacher of the Year in Higher Education by the U.S. Green Building Council of Florida, Northeast Florida region. His research focuses on environmental politics, rights, and technology. Josh's work has appeared in numerous peer-reviewed journals and has been cited in 7 UN reports. His first book is The Global Emergence of Constitutional Environmental Rights, which was published by Routledge in 2017. In his spare time, he doesn't have any, but he runs the EnviroRightsMap, Map, which is at www.envirorightsmap.org, a free Google Maps-based website that catalogs environmental rights throughout the world. He holds a BA in Political Science, magna cum laude, from the University of Florida, an MA in Climate and Society from Columbia University, and another MA and a PhD in Political Science from the University of California at Irvine. Josh, we are absolutely thrilled to welcome you and to hear more about your newest book, Rights for Robots, Artificial Intelligence, Animals, and Environmental Law. Please.
Oh, thank you very much, Erin, for that wonderful introduction. And again, I'm so pleased to be a member of the Global Network for Human Rights and the Environment and to see how it brings, as hopefully this kind of talk does, people together from different areas, not only law and political science, but activism, journalism, and so on, who all have an interest in issues at the intersection of human rights or rights in general and the environment. And I'm really pleased to have the opportunity to talk about my new book. And before I forget, I mentioned this, I believe, in one of the communications, that people who attend this talk, if of course the book is available already online and on Kindle for free, it's open access. But if you, or perhaps your library, are interested in purchasing a hardbound copy of the book, I'm gonna go now and share my screen because I have a flyer. Yeah, I'll go to flyer. So if you go to the Routledge website, and you select the hardbound version of the book, you can get a 20% discount if you enter the code FLR40 when you're checking out. So just wanted to give everyone that opportunity. But of course, I'm really pleased that the book is open access, and so it can be available for people not only in the developed world, but the developing world as well, people who otherwise wouldn't be able to afford it and so on. And so far, the reception has been really great. I'm really pleased to announce that the last time I checked on Amazon, books on Kindle in terms of the ratings, it was #1 in 4 different legal categories. And which is just, I mean, just if nothing else, a testament to the kind of interdisciplinarity with which I tried to approach this particular project. So to give people a sense of what I've tried to do here, can everyone see that now? I have the slide up, great. So I am going to present sort of a top level version of the book. I'm not going to dwell too much in the particularities of court cases and things like that. I wanted to make it kind of as broadly intelligible as possible and to hit some of the high notes about the arguments and some of the challenges that I think I tried to address in the course of writing the book. And then we'll leave the remainder of the time for questions and discussion, because it's some of the previous experiences I've had in conferences like RoboPhilosophy or the Earth System Governance Project virtual summit that we had a couple of months ago now is any indication. There's going to be a lot of discussion, and I want to make sure that we have time for people to dialogue about their concerns and also their own arguments pertaining to these issues. So as Aaron mentioned, the book is called Rights for Robots, Artificial Intelligence, Animal and Environmental Law. Although just this morning, I got the word that Earth System Governance Journal has published open access, a variation of my chapter 4, which is on the rights of nature, and specifically how it speaks to non-humans in general. And I think that's one thing that I didn't realize until I kind of finished writing the book, was that I wasn't so much specifically answering the question called the machine question, which is about the moral or legal status of intelligent machines, but also more broadly thinking about the role that non-humans play in legal and political systems during what we call the Anthropocene, which I'll get into in a moment. So I am not a philosopher. I'm not a computer scientist. I'm not a programmer. So how is it that I came to this particular question? My area of research is primarily on environmental rights. That's how I met Aaron. That's how I began my career, based on an article written by Aaron and Jimmy May about environmental rights in national constitutions. And so the next wave of research that I came across that is still developing is the research pertaining to the multinational spread of rights of nature. And I noticed that this was happening across the world, whether we're talking about legislatures, local government, and also courts of law. And so on the one hand, there was this observation, because of my own area of research, that courts and legislatures and local administrative bodies alike were increasingly recognizing the rights of non-humans, and in particular, natural entities. And then, honestly, I think this probably came about just a result of looking at things on Twitter. But I also saw that there was this rise of human-like robots who, are being devised in such a way as to more and more accurately mimic the behavior and appearance of humans. And so my natural inclination upon seeing these two trends was to ask myself, well, what about something that's totally not natural in the sense that we consider to be organic, or natural resources, like robots, and the extent to which they could have rights? Because the argument about rights of nature is not so much that these are humans and therefore they are deserving of rights, but it's rather that there are these things which for some ways may have important implications for humans, but also in other ways of thinking and other worldviews, like indigenous worldviews and cosmologies. These are entities that have their own value that does not require the stamp of human approval in order to welcome them into our legal and political systems. So I thought of this in terms of what's known as, or part and parcel of the larger machine question, and that is, can robots have rights? But being a social scientist, my background is in political science, and I dabble in legal scholarship, was to phrase this in the form of a social science question that I could then interrogate using different methods. And that is, under what conditions might some robots be eligible for moral or legal rights? And again, given my particular area of emphasis, environmental law, I thought, well, given the advances that we have seen in environmental law and also in animal law, how can we draw lessons from animal ethics in law and environmental ethics in law to kind of inform this question with something that, in many cases has not been readily made or not done as explicitly and as comprehensively as perhaps someone from the environmental realm would have liked. Typically, if you look at work that focuses on the rights of machines or the rights of robots, it tends to pay only passing mention to these developments in animal or environmental law. And so what I sought to do was make a whole book out of those kinds of questions to see if I could draw some inspiration from these cognate areas of law and ethics. Now, the book doesn't specifically address this kind of framing for what I've tried to accomplish, but I thought in the process of developing this presentation that here's what I feel like I'm actually doing in the course of writing the book. And so the goal is ultimately to answer that question about robot rights. But in order to do so, I felt like over time, I have sort of revealed to myself that this involves three related kinds of tasks. The first is to clarify conceptual relationships. And in particular, this is because of the fact that the philosophers tend to write about moral rights and the legal scholars tend to write about legal rights. And sometimes people from both camps just talk about rights in general without really specifying whether they're referring to moral or legal rights. So I wondered, is there not a way that I could demonstrate how moral and legal rights relate to one another in tandem? What are the connections that are meaningful that will allow us to gain greater clarity about whether an entity like a robot or anything else for that matter might be eligible for rights? So that's one of the central tasks that I did, and that was something I tried to achieve in chapter 2 of the book. The second is that building off of what scholars have previously done in all of these areas, whether we're talking about machines, animals, or nature, is I felt like I had to create some kind of framework for us to understand what is the process by which we could assess the candidacy of rights for machines or even non-humans in general. And there are sort of three different variations of a kind of framework that we might employ. One is a unicriterial approach, which would be something like determining whether an entity has consciousness or intelligence or intentionality, or using one phrase from Tom Reagan, is the subject of a life. So a unicriterial approach looks at one particular property of an entity and then tries to establish whether that is present in an entity or not, and then that will determine whether they have rights or legal personhood or other forms of personhood. The second kind of framework in that sort of evolution from that is a multi-criterial approach in which either a number of properties or both properties and different kinds of relations are considered central to answering that question about rights. And then what I have tried to do, and we'll see this further in the presentation, is take a step further and advance a multispectral approach, which is more akin to what Fowler has done in the area of relational personhood. He's an anthropologist, and he's written about not using a sort of binary in terms of an entity having something or not, or doing that on multiple different criteria, but rather simply specifying that there are multiple areas that need to be considered in tandem, and that an entity may possess more or less of those things depending on context. So that's, I'll show you that toward the end of the talk, but that's the sort of evolution that I see the framework building on. And then finally, this didn't happen until very late in the game. I was in the process of writing the last chapter, and I realized that what was missing was a degree of normativity. And that is a kind of ethic that we could use to incorporate more than humans into our moral or legal universes. And so again, building off of what I talk about in chapters 3 and 4, which deal with animal ethics and environmental ethics respectively, I felt that I needed to take the lessons that we have learned and then apply those in the form of an ethic that would allow us to expand the universes to include non-humans, be they artifactual or natural. So I had to do these 3 things in order to get to an assessment of whether rights were permissible. And then another way of looking at some of what I presented in the book are what I'm going to call analytical keys. And these are sort of tools that I employ throughout the book to answer questions that seemed like obstacles in the way of being able to resolve the machine question or the animal question. And so the first of those are the argument for marginal cases, which is a proof by contradiction used in philosophy that basically operates in this way. If it's possible for a human to still have moral value, despite the fact that they do not possess some criteria, some property that we would typically associate with the granting of moral status, then that might suggest that animals or any other entity for that matter that is in possession of that particular property should be considered to have moral status as well. So an example of this might be a human who is no longer conscious because they are technically brain dead according to medicine. And this is kind of in Aaron's wheelhouse, under the concept of human dignity, we might be able to say that that person still has moral status. But if we're looking at this from the vantage point of consciousness being the main criteria by which we establish moral status, well, if someone is no longer conscious, then how could that person enjoy a higher level of moral status than, say, a tree or a bug? So what this particular sort of device allows us to do is to assess the validity of those different criteria and the role that they play in assigning moral status. The argument being that, and this is kind of in Jamie's world, that if we look at sentience, for example, an animal that is sentient, and if we believe that sentience is important to our calculations about moral status, then clearly an animal possessing sentience would be eligible for rights. So the argument for marginal cases kind of looks at, and I don't like the phrase marginal has been sort of bandied about as being very controversial, and I agree to that extent. It's not the most kind word to apply in this particular situation, but humans that are in lacking some criteria, if they still possess moral status and rights, then we really need to think about how that might affect our vision for moral status as it applies to other non-human entities. A second one is a theoretical turn in philosophy known as new materialism, whose primary contribution is that all matter is something that is imbued with vitality and agency, all the way down to the molecular level. So that means that the difference between inorganic and organic entities or subjects is not really important anymore. If we can determine that actually everything has some amount of agency, some amount of vitality, then that throws into question why we have a distinction between organic beings and inorganic beings. And then finally, the one from environmental law and critical environmental law in particular, which I'll talk about in a moment, is the broader context in which we're having this conversation. And that is the Anthropocene, which is a recent geologic era that acknowledges the impact that humans have had on the environment and the fact that humans can no longer be considered outside of the environment because of the way that they are in it and act upon it. So in the Anthropocene, some of these observations are that it is no longer tenable to have a strict binary between humans and nature, that humans have always been part of nature and have always acted upon nature, and also that we need to acknowledge what I call the Anthropocene dilemma, and that is that humans are the reason for the kind of environmental degradation that we are witnessing, but they are also the only actors within the international system that are capable of coming to this realization. So it's sort of a tricky double play here because humans acknowledge their role, but also that they are the problem. And so it begins this conversation about how do we take humans and the hierarchy that they have set for themselves or be placed atop that hierarchy, and change things so that our legal systems, for instance, are more friendly to protecting the environment as opposed to solely working in the service of protecting human interests. So the fact that we're having this conversation in the context of the Anthropocene is really central to how the arguments will proceed and the kinds of conclusions that we draw as a result. So, as I mentioned, typically when trying to determine the moral status of a non-human entity, we examine this through one of two different approaches. One is through properties, and those include things like consciousness, sentience, autonomy, intelligence, and so on. And then there's another school of thought that focuses on the nature of the relations between entities, and that actually impacts how we should treat something, as opposed to simply trying to observe the presence of a property in another entity or not. And so what I've tried to do is take these two schools of thought and take the moral and legal language and see how they relate to one another. And so what I've done here is created a conceptual map that tries to put together all of these disparate pieces into a more meaningful whole that we can use to understand why we see disagreements between legal scholars and philosophers, why we see disagreements or disjunctures between getting from personhood to rights and so on. And so I'm not going to go over every single one of these little bubbles here, but I think some of the larger points are, one, that we see differences in the kinds of properties and the sorts of personhood that they might relate to. We also see at the bottom, you can observe that there are a number of relational mechanisms. I have kind of lumped a lot of these under the category of relational personhood. And again, that has to do with the way in which relational scholars like David Gunkel, Mark Keckelberg, Fowler, for example, from anthropology, have talked about relational personhood. And the argument here is that ultimately, virtually all of these kinds of properties are in essence somewhat relational. So all of them are epiphenomenal to relations that we have with other non-human entities. And then the other thing that I wanted to highlight is that in terms of I'm not gonna say this causally, but relationally, we move from properties and mechanisms to the kinds of personhood that an entity might be ascribed, and then the status that that entity might enjoy, whether it's a moral agent or a moral patient, or in the legal world, a legal subject or a legal object. And then it is from there that we see the rights to which that entity might be entitled. An important note here on the moral agent, moral patient side of things under statuses is the fact that there is still a debate about whether a moral patient is deserving of rights because it cannot contribute to the obligations under a kind of Hofeldian framework of rights that would be reciprocal and allow it to enjoy rights because it is part of the community that is able to use its own agency to meet the obligations that it's set forth by the members of the community. So one of the insights in the book is just that we need to relax this assumption if we want to think of entities that do not have agency in the traditional way that we think of moral agency to possess rights. If people disagree with that, then it's going to be a much higher hill to climb to get to rights for a non-human like a machine or an animal or nature or anything else for that matter. Another final thing that I'll note here is that I don't specify the particular kinds of rights that an entity might be entitled to if it is deemed to be eligible for rights in general. And that's deliberate. I leave that open for interpretation, although we know from the work of David Gunkel and Adrian Lima, for example, that probably the best case for the first kind of right that we might see emerge in the instance of intelligent machines might be the right to be free from cruelty. And that has a direct relationship to animal rights, interestingly, which I argue in the book is not a particularly good model for the rights of intelligent machines or artificial intelligence. So This conceptual map is not the end of the discussion. It is what I hope will be the beginning of the discussion about how we could view moral and legal issues in tandem, and hopefully gain greater clarity about how different forms of personhood, different kinds of statuses, and different forms of rights might relate to each other. So now moving into the kind of substantive chapters of the book themselves, I look at environmental ethics. And in particular, there are two major schools of thought. The first is biocentrism. Biocentrism is life-centered. And basically what that means in the context of an ethical approach to the world is that a biocentrist focuses on individual organic entities, views humans and those entities as having equal moral status. But as far as rights, it does not really ascribe moral rights, but it does provide the space for legal rights for those entities. An ecocentric approach is nature-centered. It is, unlike biocentrism, holistic in the sense that it ascribes moral status to whole ecosystems, whole biotic communities, which is very different than an individualistic, more human rights-like based approach as we see in biocentrism. It importantly also acknowledges that humans do not occupy a place of superiority to any natural entities. And in fact, humans are just another knot in the ecosphere or biosphere. And then finally, as far as rights are concerned, an ecocentric approach would argue probably that rights might consist of things like the right to live or the right to thrive. And that would be directed at an entire ecosystem, but not necessarily the individual units comprising that ecosystem. So everything within that ecosystem is not viewed as being any more special or significant than any other entity, which is disrupting this sort of anthropocentric idea that still somewhat infuses our notion of human rights in general and is not fully disrupted in the context of biocentrism. Critical environmental law is one of the big pieces of the book, really. And that what I hope to have done, if nothing else, is really introduce critical environmental law to philosophers, to computer scientists, and so on. And there are two key insights that I want to speak about that critical environmental law offers to this particular debate. The first is critical environmental law redefines nature and its relationship to humans. Like the Anthropocene and the insights provided by it as the context in which we're proceeding, a critical environmental legal approach identifies nature as not being separate from humans, and that it never was. And so it would be improper to treat nature as something that is inferior to humans, whether we're speaking about morals or legal implications. And so one really great metaphor that I came across in describing what this looks like is that nature is also not static. What we think of as nature expands and contracts depending on the context. So when we're thinking about something like the nature that is relevant to Four Corners Park in my neighborhood, when we're dealing with environmental protection issues there, the natural surroundings are somewhat delimited. But that's different than, say, concern about fires in a bioregion or climate change as a transboundary issue that is global. And so what a critical environmental legal approach says is that nature, as we understand it, is not simply the outdoors, a mountain range, your local park, or anything like that. It is heavily context dependent, but it is always something that is in flux depending on the situation in which we are having a conversation about the relevant boundaries of nature. And then second, people like GNHRE have paid a lot of attention to how critical environmental law sort of disrupts this idea, this conventional notion of what we think a legal person is. So typically we know that there are two types of legal persons. There are natural persons and there are artificial persons. A natural person is a human exclusively in most cases, and an artificial person is something like a corporation, which no one would ever mistake for a human, but nonetheless, we have reasons to consider it as a legal person for reasons of expediency or resolving conflicts or other matters. So recognizing that that has been the case for hundreds of years, especially in Western legal systems, critical environmental law says, actually, we need to rethink this because the conventional notion of legal person has resulted in both intra-species hierarchies, like treating humans as substandard compared to other humans, and also interspecies hierarchies, where humans are viewed as more legally significant than, say, animals or intelligent machines or nature and so on. And so part of the insight provided by critical environmental law is that there are actually always assemblages, to use a Latourian concept, of humans and nature coexisting. So people like Matilda Arvidsson have talked about human natural entities being sort of hybrids, like swarm robotics, for example, where a human is operating a device that looks and seemingly is sort of operating off of a biomimicry kind of approach, but it's difficult to really determine where the human begins and where the artificial machinery ends and so on. We see this with the post-human or transhuman movements as well, where people are becoming more and more fused with forms of technology, whether it's from a pacemaker to having a computer chip like Neuralink embedded in their brain. So there are going to be these questions about the fluidity with which we view legal personhood. One of my favorite thought experiments related to this is one in which a human brain has all of its cells replaced one by artificial brain cells. And so you go one by one, and then eventually the human brain, even though it is organic, now has only artificial brain cells. And then you rework the process to replacing the artificial brain cells with ones that are organic. At what point was the human no longer considered to be human if, for example, intelligence is the criteria that we're going to use to determine personhood? So those sorts of questions allow us to shake up what we conventionally think of as a legal person. In the book, I talk about specifically how this relates to corporations and ships. But the insight provided by critical environmental law is that we need to cast aside traditional notions of legal personhood in the Anthropocene, because it's no longer the case that it's easily identifiable that humans are completely discrete from nature or even technological entities for that matter. So I'm not going to go into the weeds of each of the rights of nature cases that I talked about in the book. These are some of the most celebrated cases that have come out in the past several years from across the world. But I do want to highlight briefly sort of the origins of the rights of nature, which shows some of the dynamism of this concept and how it has gained a foothold in places like the developing and developed worlds. So the rights of nature really owe an intellectual debt to indigenous cosmologies and this idea that that nature is not something to be viewed as external to or separate from humans, but rather there's this notion of kinship in which humans and animals and nature all occupy a similar kind of cosmological status. That idea has resonated in the American legal system and was picked up in the early 1970s by Christopher Stone, who was teaching a course and had students ask this question about whether a tree, clearly as a non-human entity, could have standing in a court of law. And this turned into an article which influenced American jurisprudence in the form of a dissenting opinion in a famous case, and then turned into a book, and has now materialized into a movement that has been taken up by organizations like the Community Environmental Legal Defense Fund that advocate for the advance of environmental rights in national constitutions like Ecuador's, but also in the recent election, the state of Florida had a citizens initiative passed in the county of Orange, which granted rights to a river and also made water a right. And so we're seeing this being taken up not only in places like Pennsylvania, where it sort of began in the United States, but now we're even seeing it in Florida, and other counties are pursuing similar legal measures, not through the courts, but rather through referenda and other sort of citizen initiatives, putting it before the people to a vote as opposed to having it decided upon by creative judges. But anyway, back to the rights of nature in court. We have seen lots of creative legal interpretations being used throughout the world. The cases that I highlighted here come from largely the developing world, where we've seen most of these kinds of advances. Interestingly, I'll just look at the source of legal reasoning has always been multifaceted in these cases, in the sense that they do not give pride of place to only their own domestic law, but they also look at ideas emerging from indigenous groups, international law, and so on. So it's really kind of an accumulation of different forms of legal ideas. The ethical approaches that are evidenced in these decisions are uniformly ecocentric and not biocentric, which is not surprising because of the way in which they disrupt this idea that humans are in somehow more important than the natural surroundings that they are impacting. And then finally, I looked to the extent to which critical environmental law could be seen in these legal decisions. And in all of these cases, we don't see nature being redefined in the kind of, to use the metaphor of the amoeba, that sort of way that critical environmental law advocates for. But we do see in each of these decisions a clear advocacy for decentering humans from the center of the moral universe, and also de-individualizing legal subjects to make humans on the same equal plane as anything else that might come before the court in these particular cases. So although these cases clearly do not speak to global trends that we're seeing all throughout the world, I don't think we're likely to see, for example, the US Supreme Court take these issues up and agree with the kinds of legal reasoning that have been employed in these cases. But I do think that the kinds of common threads that we see emerging are significant in the sense that we do see signs of critical environmental law cracking through and making important innovations in how we think about the role of humans. And this has, for the purposes of the book, important implications for whether we might be able to apply the same reasoning to non-human, inorganic entities like intelligent machines in the future. So now shifting gears for a moment to animal ethics. I classified animal ethical approaches in 4 different categories. The first is properties-based, and this is the most common and probably most widely understood basis for animal ethics, and that is that animals, by virtue of possessing some kind of property, whether it's sentience or consciousness or intelligence, should be afforded moral or legal status. And so that's kind of the bread and butter of the animal ethics movement. But then there's another sort of prong to this, and that is direct and indirect approaches to animal ethics. And so direct and indirect approaches take a page from Immanuel Kant, and they argue either that how we treat animals has some sort of significance for how we treat other humans, which is kind of an indirect way of looking at the reason why we might afford moral or legal status to animals, or directly that how we treat animals has an implication for human emotions. And if we feel bad, then it should be a signal to us about how we should treat other entities. So that's kind of another branch of the animal ethics tradition. The third one is one in which, again, we look at relations as being front and center, where we don't consider a single property like consciousness as being important, or human emotions or human duties towards other humans, but rather it is through the course of our interactions with animals that we establish the kinds of moral or legal status that they might be afforded. And then finally, I included this, although it's not strictly a kind of ethical approach, but I felt like it was relevant, and I honestly didn't have another place to stick it, was the sort of legal approaches that have been used to describe our animal ethical understanding. And so the 3 major ones that I highlight in the book are animal welfare, which is talked about by Cass Sunstein as being important enough to require, or to rather not have rights become part of the conversation, although I disagree with this. And in fact, in another article that Sunstein wrote later, he argues that actually we can use things like marketing strategies like eco-labeling in order to have the consumer understand what the ethical implications are of their own purchasing habits. So they might pick up, for example, a quart of milk, and it will say, only 4 cows died in the process of getting this milk to your supermarket. And that would be significant enough for the consumer to say, oh, clearly there was animal harm going on there. So I'm going to use my own judgment as an ethical consumer to not purchase this milk, and maybe I'll purchase oat milk instead or something like that. The second one is an argument made by Randy Abate, and that is that he makes an analogy between animals and nature or natural resources. He calls them all part of what he says are the community of the voiceless. These are entities that cannot really directly interface with our legal systems. So by their very nature, we are going to have to advocate on their behalf. And so he says, this is sort of the basis for the book in a way, if nature clearly is not a human in any important way, it doesn't breathe, it's not conscious, and so on. So we can't say that nature is a human, but it nevertheless has rights. Then it's even more easily made the case that animals clearly should have rights because they're even more similar to humans than nature is. And then finally, a really interesting argument was raised by Bradshaw in 2018. And she argues that in the case of wildlife, one solution might be to give the right to property to wildlife in land and sea in order to prevent it from being harmed. So what all of these different approaches have in common, as you can see evidence here by the little icons that I have on the left side of the slide, are that they're always under-inclusive. And this was even from a very lay perspective before I ever embarked on this book, a question that I had when I watched a documentary on animal rights. And I wondered to myself, why is PETA not advocating for the rights of spiders? And it's because there are certain, whether it's because of their charisma or because of the traits and properties that are associated with those animals, they are granted a certain status, whether it's moral or legal, that other animals are not. So in the little icons you have here, you have wildlife, you have domesticated animals, you have farm animals, all of which are protected under one or more of the kind of ethical approaches described on this slide. But the crab, it's not immediately clear that a crab would be protected, for example. So my issue with animal ethics is that they seem to have not come up with something of a covering law to be able to provide for all animals everywhere, and where should we draw the line, if at all. If you think about the famous animal rights litigator, Stephen Wise, he would say that we have a scale of practical autonomy, and that different animals appear at different points on the scale, and we should sort of scale our obligations toward them accordingly, which gets a little bit more complexity into the conversation. And so I certainly appreciate that kind of an innovation. But in the cases here, my argument is that the animal ethics literature is severely under-inclusive and also doesn't really give us a whole lot when we're looking at non-organic entities like intelligent machines. And so to go to the animal rights, we have a number of cases from around the world that also speak to animal rights issues. And I definitely want to leave some time for questioning, so I'm going to kind of march through this. But the point is that we see a lot of differentiation between jurisdictions. The different animal rights approaches taken range from based on specific properties to legal arguments, and then in some cases even direct, indirect approaches about our duties to other humans or human emotions and things like that. But the major point here is that we have not been given a whole lot that would be useful when analyzing the rights of non-human entities, especially where the criteria or properties used to assess their moral or legal status, like sentience or consciousness, is not empirically verifiable, at least immediately, or something that we could ever potentially do if you follow the work of some cognitive scientists and philosophers. So we've seen some really interesting work come out of the animal rights jurisprudence, but it's not necessarily as portable as the literature and the jurisprudence on the rights of nature. So what I have done is tried to bring all of this together. And again, in the service of moving from a unicriterial to a multi-criterial to what I call a multi-spectral approach. And that is looking at different forms of personhood and how they all relate back to moral, or rather relational personhood at the bottom right of this graphic. All of these being pertinent within a social relational context, and then decisions being made morally or legally within a broader social ecological context. So I'm borrowing here from Mark Keckelberg, who has talked about social relational, social ecological contexts, but I have fit into that model these different forms of personhood, and then the different sort of criteria relative to them and how they are relevant on a sliding scale. And those are their mentality, which deals with cognitive abilities, autonomy, which deals with things like intentionality, legal personhood, the legal capacity of an entity, or its utility, which really deals with whether humans have a justifiable reason for welcoming these entities within their legal system, like, for example, because it will help to resolve conflicts, as we have seen in the case of ships. And then finally, relational personhood, which deals with the context in which these relations are being adjudicated, and also the materiality or physicality. And that is, what is it made of? What does it look to us? What does it look like to us? Because we know that anthropomorphism, for example, has an impact on how humans view other entities. And so I felt like it was important to have the physical nature of these beings included, because I didn't want to fully extricate the properties which are some people have argued are very morally and legally significant from the larger calculus of the determinations that we make about their candidacy for rights. And I specify this a whole lot more in the book, but I just wanted to make sure that I got to that point. I'm going to march through this pretty quickly, but a critical environmental ethic has three components: an ontological, an epistemological, and normative. Ontologically, it shifts from the vision a lot of human rights is focused on, which is individual, and moves to a kind of radical holism. It moves from an anthropocentric view to a more ecocentric anthropic view, which means simply that humans are capable of acknowledging that we're the party responsible for making decisions, but we shouldn't be at the center of the moral and legal universe. The epistemological side is an Anthropocene-inspired radical equality, which is really probably the most radical thing about this particular ethic, and that is we need to be able to make decisions legally and morally in which humans are not given pride of place. And then finally, the normative dimension is that the decisions that are made about our moral and legal calculations need to be ecologically sensitive, and they need to promote justice and equality. That needs to be the framework through which we decide how to adjudicate these kinds of issues. So a couple of quick examples that I found really interesting, which speak to the fact that this is, even though it seems like maybe a mental experiment or a flight of fancy for philosophers, it's actually having real world implications here and now. YouTube removed videos of robots fighting because the algorithm determined that they were tantamount to animal abuse. And so that made news a couple of years ago. These were not, by the way, robots that looked like animals. They looked like mechanoids or just typical machines, but some people found them to be very violent and also suggestive of violence to other non-human entities like animals. And then there's a famous video from Boston Dynamics in which the humanoid bipedal robot Atlas was hacked at by some of their scientists with a hockey stick, and people were outraged and wrote all kinds of comments like, I hope that the robots see this when they finally take over and they know who to go after, or I feel sad for the robot. And even though they're clearly not a perfect, examples of human-like forms, it was enough to where people expressed some kind of emotions and sadness toward the way that these robots had been treated. So I'm going to show you a few examples of my research in Japan from a couple summers ago, where I tried to go out into the wild, so to speak, and see what robots are being developed, how they operate, and what kind of example might this set for the kinds of robots that we will see in our everyday lives. So the one you see here is the Lovat on the far left, which is not so much of a humanoid looking robot, but a kind of cuddly one that's going to be used in Japan to provide companionship for elderly people. And so it is kind of a cuddly form. It has digital eyes that are customizable, and the energy that is expended in the course of the motor running is distributed throughout it so it feels warm to the touch and inviting for its users. This is Asimo, Honda's robot that's at GNHRE, which is a science and technology museum in Tokyo. And it does several times a day a kind of exhibit or kind of like a performance, if you will. And people were clapping and all sorts of things like that. It kicks a soccer ball, it dances, it sings, and all that. And then this one is Pepper, which is a robot that is shown in SoftBank, which is a commercial bank that is in Japan. And it sort of serves as a concierge for people who enter the store. So anyway, I went a bit over my time, but I want to make sure that we have a lot of opportunity for questions and comments. So thank you for your time and attention. If you want to download the book, there's a QR code you can use to scan the book. It'll take you to the free open access version. Otherwise, like I said, you can purchase the book in hardcover format from Routledge or from the Amazon website. And so that's all I have. I'm going to back out of this, and then we can hopefully take some questions from members of the audience.
Okay, great. Thank you so much. That was just fantastic, Josh. Incredibly thought-provoking and just a really great example of the amazing cutting edge and interdisciplinary work that you and others are doing in this area. We don't have a lot of time for questions, and we have a few questions, and what I'd like to do is just read them out to you, and I'll just read them as a bunch, and you'll sort of get the themes that are embedded in them, and maybe try to respond to as much as you can. And part of the reason that I'm reading is just because the questions themselves are so thoughtful and interesting that I just want to give them their due and not paraphrase them. So first, while it's conceivable to assert that human rights derive from moral imperatives, what's the basis for bestowing robots with, quote, rights? In your periscope, can robots bear certain legal obligations? So the flip side of rights. And as a follow-up, assuming that robots were to enjoy rights, what could be the nature of such rights? For example, nature's right or rights of nature or environmental rights presupposes environmental sustainability and protection, amongst other things. I was wondering what form that of robots will take. Another question, my main concern about eco-biocentric holist and also relational approaches is that they seem open to the risk that us humans can find ways to justify disregarding suffering of some other types of being. Do you think that's a valid concern? And does your multispectral approach provide sufficient mitigation of that risk? What are your thoughts on who gets to choose the criteria, whether one multi or multispectral rights? Critical scholarship philosophers look to politics of power, noting how dominant groups tend to choose these criteria and thus cause harm by exclusion. I guess this is a problem, as you pointed out in that one Boston situation where people are concerned about what happens when the robots actually start taking power. And then last, you mentioned cruelty towards a moral patient. Do you have a conception of cruelty towards robots? In your opinion, what does it mean to harm a robot? Do you think this question somehow involves a category mistake? Could keep asking this question already mean that one is buying into a properties approach? Should a relationist approach reform this question in a different way? Do you have a suggestion? So a lot of things to think about. We only have a few minutes, so give it your best shot.
Well, thank you everyone who attended and also everyone who asked questions. I mean, these could all be the subject of a paper on their own. So, I just want to say I will not be able to do justice in the time that we have remaining, but I do want to get to at least a couple of them. And so the first question about bestowing rights with robots and whether they could bear legal obligations, I think this relates to the question of moral patiency. And I would simply respond that for the same reason that we don't require babies, human babies, to have legal obligations, I think that we could extend that same logic to other non-human entities like intelligent machines and say that it's not necessary to have rights, or rather to have be able to comply with legal obligations in order to have rights. Otherwise, we would have more difficulty with some of the cases of humans, which are not, for one reason or another, able to also meet those legal obligations. The second question, what's the nature of those rights? Presupposing environmental sustainability. I think the issue here is, I guess what I'm trying to do is demonstrate how rights of being afforded to even artificial entities like robots actually serves the purpose of substantiating non-anthropocentric worldviews, in the sense that if what we are missing, and the reason why we are in the position we're in, is because humans have placed themselves atop the moral and legal hierarchy, then diminishing that role and viewing ourselves on a plane of radical equality where everything and anything could potentially be vulnerable to some sort of harm might address that problem. So even though maybe say, the way that we treat a robot isn't on its face something that deals directly with environmental sustainability, it is the kind of ethic by which we arrive at sustainability that creates the space for thinking about how we treat non-human, even inorganic entities as well. The third question, thank you very much for both of those were great. From Jamie about the issue with relational approaches that could potentially see the creeping of harm. I think it's an interesting point. And I guess the issue is, if we follow the sort of the logical implications of the critical environmental legal approach, it really casts a very wide net for the kind of harm that could befall any range of entities at all. I think the issue is, maybe to kind of reframe what you have written a bit, is what happens when we get into a conflict. I don't really have a strong answer for that at this point. I think that would be a great sort of follow-up, but I don't think that suffering in and of itself would be precluded from this discussion. I think that who is suffering is part and parcel to a critical environmental legal part of this discussion. But then the question becomes, well, what happens if a robot is suffering, ostensibly, while a human is suffering? How do we choose if we're sort of in a trolley problem or something like that? I haven't worked out the answer to that yet. So I think Jamie's point there is very well taken. And then the last one I'll be able to get to here, because I know people have other places to go, is who gets to choose? That is another question, which is really great, which I also didn't address in the book, other than to say that particular decision is fundamentally a discursive and political one. Rafi Yuat at the New School talks a lot about this in the context of personhood, and says, wait a minute, what we have to think about here is the very question raised by Ian, which is who gets to decide? And that is oftentimes produced through a discursive and often contentious process. So I would hope that through advocacy, we would be able to have some kind of conflict that results in a description about the criteria that are used to determine these sorts of entities and the extent to which they are welcomed into moral and legal universes. But I don't think it should be decided by a judge. I don't think it should be decided by a legislature. I don't think it should single-handedly be decided by a group of citizens. It seems like it needs to be a discursive and perhaps even contentious process that results in some kind of answer, which would be deemed democratically legitimate. But that's a terrific question. Again, we're a few minutes over here, so I don't want to make anyone late for other meetings or other obligations. But I just want to say again, I really appreciate everyone who came and attended this talk. I hope you get an opportunity to download at least a free version of the book. Think about how the different legal and philosophical arguments relate to one another, and how animal rights and ethics and environmental law and ethics also might inform other questions that are pertinent to your own research. My message to students who might be viewing this and who I've talked to in high school is, don't be afraid to think outside of your own comfort zone. I did not set out ever to write a book about robots, and I did not know a lot about artificial intelligence before embarking on this project, but just through my own area of interest in environmental rights, I felt compelled to do some more research, and it has resulted in what I think of as a tremendously productive, helpful, and interesting exercise that has pushed me as a scholar, and hopefully has invited others into an inter and transdisciplinary conversation that is going to be fruitful for moving forward in terms of how we think about rights and how we think about law and morals. So again, thank you so much for all of the time and attention. And I hope if you have any other questions, feel free to email me or find me on Twitter and we can continue the discussion there.
Thank you so much, Josh. Thanks to everybody who joined. This was obviously just such a rich and thoughtful conversation. We really appreciate it. And we're looking forward to reading the book for those of us who haven't read it yet, which you can get for free, as he said, online. And also, I just want to remind everybody that the video of this presentation will be available on the GNHRE.org website very shortly. So thank you again. A very, very big virtual round of applause for Josh. Thank you.
Take care, everyone.
Bye-bye.